Lords, my ladies, my name is Donald Dare. My lords, my ladies, in the little time left, I'm constrained to speak about just one issue, and that is the irregularities. The irregularities that the petitioners contend and aver were visited upon the election of 26th October. And these are found in their petition, starting at paragraphs 21 to 23, and also at 105 to 133, and in a number of affidavits, especially that of Billy Atudo, especially at paragraphs 35 to 62. And my lords, my ladies, the contention of the petitioners is that there were extensive illegalities and irregularities in the preparation and execution of this October election, that these constituted substantial violations of the Constitution and the election laws, and that this would compel that the election be invalidated. Indeed, my lords, my ladies, in Presidential Election Petition 1 of 2017, which my colleagues have been referring to as Raila Odinga 2017, this honorable court held that an election will be vitiated on account of illegalities and irregularities. So it is settled law that if we could demonstrate the illegalities and the irregularities, the court might find itself with no option but to do that which it said it would do in Raila 2017. My lords, we contend that there were a number of irregularities, and in addition to the affidavit of Billy Atudo, we also appreciate indeed the affidavit supplied by the respondents, especially the third respondent, because a lot of them are actually corroborative of our own affidavits. We contend that there were irregularities in the voter register, that there were irregularities in the voter turnout, or more accurately, recording the voter turnout, which involves identifying those that are allowed and not allowed to vote. And three, that there were irregularities, again, in counting, tallying, and transmission, more or less the famous Forms 34, A, B, C, and indeed Form 32A. With regard to the voters' register, my lords, my lady.
Excuse me, what irregularity was there in counting?
Sorry, in Form 34A, in the recording of the counting in Form 34A.
Okay, can you say a bit more on that?
Yes, my lord, I intend to. Yes, my lord, I intend to. So to just go first to before the voting day and then the voting day and after the voting day, and in so doing address the voter register, and then the turnout, and then the counting, tallying, and transmission. My lords, the voter register continues to be a moving target. The voter register is like the Incredible Hulk, which starts at size, bloats up to fulfill certain tasks, and then shrinks back again when that is done. The voter register that we started out with in June is what we have now. But in between, it has bloated. In June, in the gazetted voter register, we had 19,611,423 registered voters in the gazetted voter register. In August, when announcing the results of the August 8th election, we actually had two different figures, both of which were higher than the June figure. The chairperson of the IEBC, when verbally reading out the results, read that the total number of registered voters was 19,631,796. So from 611,423 to 631,796. Yet, when the Form 34C was ultimately gazetted, this figure now was 19,611,457. The Form 34C, in relation to the October election, now has a figure exactly like that gazetted in June, and that's 19,611,423. So between June and August, the verbal announcement at least, there was an increase of registered voters numbering 20,373.
Where is this verbal announcement?
The verbal announcement is referred to in our bundle, volume 1. My lords will get for me in a second, and I'll get back to it. So we see numbers that vary, go up and go down. The next thing, my lords, just to save time as I try and get that for me, is with relation to identification and authentication of those who are entitled to vote. Regulation 69, my lords, or my ladies, of the Elections General Regulations, 2012 as amended, refer to, and this again was interpreted and was referred to yesterday in Civil Appeal number 258 of 2017, that talks about the difference between biometric identification and non-biometric identification, and describes that the fingerprint identification is a biometric identification. And there are a number of other non-biometric identification methods, or rather authentication, which include alphanumeric document search, alphanumeric and document search. So looking at the figures, and this is in the table in paragraph 15 of the affidavit of Billy Atudo, but also is in the report, the Otimofo report, as I said, which was shared by the IEBC and also is part of what we got from the third respondent. We look at those that were identified by KIMS in the first instance and those that were identified using the other means. And the figures that we have, or the figures that are then coming out, is that a total of 5.5 million people were identified by KIMS in the first instance. That's biometric identification. Then another 1.6 million were identified alphanumerically. And 428,043 were identified by document search. And there's a smaller figure of 78,124 who were not identified on the KIMS kit at all, and therefore were on the copy register. So my lords, my ladies, with regard to this, we should have access, and we did ask for, the Form 32A. If we could have Form 32A, or if the IEBC could demonstrate that they do have Forms 32A in respect of all that were not identified biometrically. Remember, biometrically identification were those that had the fingerprints. So could it be beyond those that had the fingerprints, if one looks at those that were identified by document search, those who were identified by ID or passport number, either by keying in, alphanumeric keying in the ID or passport number, or by scanning the barcode. If you look at this figure of 1.6, access to the Forms 32A would then be able to help us verify that indeed they were identified properly.
With all due respect, my lords, are we reopening scrutiny application?
Please.
Okay.
Let him finish.
Okay. All right. Thank you very much, and thank you, Kimani. Then moving on to the issue of rejected objected votes and disputed votes. And the Forms 34A and Forms 34B. Yes, my lord.
I was wondering,
Yes.
help me to recollect, rejected and disputed votes, are they in your petition?
Okay. Because I can't find out immediately. Not as an issue, my lords.
So you can't submit on what is not in your. I'm being magnanimous to you and giving you a bit of time, but I can't allow you to submit on what is not in your petition.
My lords, I'll skip that for now. With your indulgence and with gratitude, I'll skip that. Let me say that. I'll skip that. I'm sorry. I think just the rush of time is also putting us in an agitated, anxious position. So let me move on to the forms, my lords. As I said, that we had issues around the voter register, around voter identification, and around the forms. And to be very brief, my lords, my ladies, let me just talk about them in the sense of Forms 34A, Forms 34B, and leave it at that. And if I have a moment, I can then sum up. With Forms 34A, part of our contention.
Mr. Dare, if I may just be of help here.
Yes.
You've been given orders to access the originals of 34A.
Yes.
Will it help your case if you wait for whatever you're going to get there, then in your submissions tomorrow, you can raise that issue? Otherwise, I'm seeing a situation where you raise some issues now on the forms, and tomorrow you do the same thing. How do we save time? And you're not helping us with that.
Thank you very much, my lord. I thank you for that. And I think that we will go with that we reserve any observations on the forms until tomorrow. In so doing, my lords, I would then not also go on to the authorities that I had that was in relation to that, and let that also come tomorrow. And I would just say that in finishing, I would like to just add a word in answer to the question that was asked by the Honorable Professor Juang around those that chose not to vote. And on top of what my colleague said, to just say that there are those who chose not to vote, but there are those who could not vote. And the worry were those who could not vote for one reason or another. Those who could not vote because the polling station did not open, those who could not vote because of intimidation, those who could not vote because of violence, and knowing that the submissions that my colleagues have made is the intimidation and the violence, in our view, were both from state as well as non-state actors. So in summing, on the election that was to happen in 60 days, we believe that the order of the court and also the requirement of the Constitution and the laws is that it's not just that there must be an election in 60 days, but that that election must be in strict compliance with the Constitution and with the laws. And we feel that if this was not possible, or if the contention is that if the first and second respondent, the National Returning Officer, and the Independent Electoral and Boundaries Commission, if the totality of everything before them, the decisions of the court, including adding candidates that they did not initially add, the violence that had occurred, any other logistical challenges, if they felt that they would be forced to do an election on the 60th day, but that was not in strict compliance with the Constitution and the laws, they had the option of coming back to this honorable court and seeking the directions of this court. That what do we do if the time is running out, we need to hold an election, but it will not be in strict compliance with the dictates of this court, but more importantly, of the Constitution and of the laws. And with that, my ladies, my lords, I beg to rest, and thank you for the indulgence that you have shown to our entire team.
Thank you. Thank you very much, Council. I think that is a good point to adjourn. Please go and have lunch. Have enough to keep you up to the time we rise. So we will